If you've received a notice of intended prosecution or a request pursuant to Section 172 of the Road Traffic Act 1988 from the police to identify the driver of a vehicle, failing to respond may mean you face a charge for an offense known as failure to furnish driver details. This offense typically occurs when the registered keeper of a vehicle does not respond to a request for driver information within the required 28 days or provides incomplete or inaccurate information. While it may sound minor, the consequences for failing to furnish driver details is hefty, with a minimum penalty of 6 penalty points and a fine up to £1,000. Whilst failing to furnish driver details offenses are serious, it has become incredibly common for the motorist to name other people stating that they were driving, often stating they were from out of the country or unreachable by other means. This is something which you should never do under any circumstances. Providing false information to the police often leads to an investigation and potentially a charge for perverting the course of justice, which more often than not leads to a prison sentence. The potential of penalty points being endorsed on your license is not worth the risk of going to prison. Failing to furnish driver detail cases are not always clear-cut. Sometimes the notice and requirement never arrive. Other times, it may be difficult to assess who was driving at the material time. In many cases, you may have a legitimate defense that we can explore to avoid a disqualification altogether. It is important to note that the legal obligation to provide driver details applies equally to companies and their vehicles. Companies are expected to maintain accurate and up-to-date records of who is using their vehicles and when. By doing so, a company ensures their ability to respond to the notice of intended prosecution and also demonstrates that if they have taken reasonable steps to identify a driver of one of their vehicles, if there is any uncertainty on who was driving. Unlike individuals, companies can only receive a financial penalty for the offense of failing to furnish driver details, though it is not uncommon for the police to pursue an allegation against the company director or the company secretary if no response is received. Whether you're an individual or a company, Olliers can help. Our team specialize in motoring law, and we understand both the technical and practical defenses available in failing to furnish cases. We'll take the time to review your situation, explain your options clearly, and work with you to achieve the best possible outcome. If you've been accused of failing to furnish driver details, don't leave it to chance. Get in touch with Olliers today for clear advice and expert representation.